Patent Act, Patent Act of 1970, which has been amended twice in the past 10 years now, more than 10 years. And the first amendment that took place was in 1999. So we're going to give you a background of that in the light of the various agreements that India became a part of, international agreements, and therefore the obligations to comply with these national standards and norms as well. As also, the session will also cover the various administrative and procedural sections of the Patent Office to give you an understanding of how the Patent Office actually functions, what is the hierarchy out there, and how does it administer the Patent Act in India. So let's take a quick look at the background. The recent amendments, we've already touched upon these amendments. So the patent legislation of India is enshrined in the Patent Act of 1970. Due to various international norms such as the TRIPS agreement as well as the Paris Convention, India was forced to carry out amendments in the Act, and these were done in 3 phases. The first amendment took place in 1999, the second amendment took place in the year 2002, and the third and the last amendment has taken place in the year 2005, with effect from January 1, 2005. The procedure governing the practice of patents is covered by the Patent Rules 2003. These rules have also been amended twice, in 2003, 2005, and in 2006. And presently, we also have Draft Rules 2010, which have been floated for public opinion, and very soon they will also be incorporated. Let's also take a look at various international standards or norms that India pledged to comply with when it became a part of these international treaties. So let's take a look at Article 78 of the TRIPS Agreement, which says that where a member does not make available as of the date of entry into force of the WTO agreement patent protection for pharmaceutical and agricultural chemical products commensurate with its obligations under Article 27, that member shall, notwithstanding the provisions of Part 6, provide as from the date of entry into force of the WTO agreement a means by which applications for patents for such inventions can be filed. To explain this, let me just give you a background about this norm. Well, before India joined the TRIPS agreement, India was not allowing patents patents for products pertaining to pharmaceuticals, agricultural, and chemical sciences, and we were primarily providing patents only for profit. However, the products such as apparatus, devices, or other engineering and mechanical devices were, of course, given the profit tax. The term of patents was also not uniform. We were having a 7-year term for a process patent which was related to a chemical or a pharmaceutical product, whereas we had a term of 14 years for other products and processes which were pertaining to the engineering side. So this is also a very kind of a non-uniform trend that we had in our law about the term of the patent. So when Article 78 of the TRIPS imposed this obligation on India that if you are not allowing product patents at the time when you have become a member of this treaty, then you will have to provide at least a means for filing of such applications in your country. So here, just take a look at Article 78A. It says that the member country shall provide a means by which application for patent for such inventions can be filed. So since we were not allowing product patents in the field of pharmaceutical and agricultural chemical products, as was required as an international minimum standard, we were supposed to allow all the member countries to file applications pertaining to these categories of products in our country. So, as you see, agricultural chemical products and the pharmaceutical products and this mean. So now what was this mean? So India created something which we call as the black box or the mailbox division, by which the international community and the members of this particular treaty, the WTO TRIPS Convention, could file their applications for grant of patent on these three categories of products with effect from 1st of January 1995. So this was a means which facilitated the filing of such applications. However, it did not entail the grant of patents on these applications until the expiry of a 10-year transition period, which India had sought. Now, India being a developing country, requested the international community to give them a 10-year transition period to comply with the basic minimum standards, and therefore amended the law in 3 stages. So, first of all, they created this black box means, and during the 10 years transition period from 1st of January 1995 to 31st of December 2004, about 8,800 applications were filed to the black box means in India, which covered pharmaceutical products, agricultural products, chemical